The Commercial Law Study Guide is intended for all trade and business professionals who wish to focus their professional activities on meeting the needs of companies. It is a compendium of tools, techniques, and tips that allow professionals to understand the law that regulates the market and therefore make informed decisions. The study guide provides a comprehensive overview of the key elements of the trade activities through theoretical and practical insights. It is designed in such a way that it thoroughly explains what this discipline consists of, showing in a detailed way the tools and techniques, types of companies, contracts, documents, bankruptcy law, etc. And at the end of this guide, in the appendix section, there is an updated article and a monograph dealing with trade documentation as well as the case study. All these will help you to have a deeper understanding of the discipline and to attain a more complete vision. Trade law. For a long time, trade has been conceived as an economic and social phenomenon. Commercial law, a branch of civil law, was born in the Middle Ages as a set of rules created to regulate the activities of unions, merchant associations of the medieval commercial towns, but it was not until the 19th century that we first started to place value on the acts carried out in commercial activities. Nowadays, commercial law has progressed in the regulation of business professionals, companies, and consumers. Sources of commercial law. Well, there is no theory about the sources of commercial law since it was created based on law and custom. It is a uniform and continuous practice of the uses and customs by traders that make such use and customs considered law. We can define the trade usages as the normal of objective law created by the repeated, uniform, and constant observation of the merchants in their business. We can distinguish between various types of trade uses, conventional, which represent the typical content of a contract, and regulatory, which represents the objective rule of law that prevails when the content of the contract is contrary to the norm. Customs, on the other hand, are stronger than trade usages since they can create legal rules for themselves. Although the Commercial Code establishes that commercial uses are genuinely sources of commercial law, since they may be used to resolve doubts rising from interpretation of contracts, it must be borne in mind that the rules of civil law need to be taken into account before commercial uses. All in all, the following are sources of commercial law: the custom, the jurisprudence, the law, the doctrine, the contract. Company register. This type of public office serves the purpose of protection, accountability, and control of issues in operating companies. Every country normally has an office in charge of the registration of this data. In Spain, for example, is the Registro Mercantil, which is responsible for the above-mentioned tasks. In fact, it is the main legal instrument to make business deals. Now, the organization of the company register. Well, worldwide, there are numerous structures and possible organizations for a company register. For instance, and continuing with the earlier example, the Spanish company register consists of local registries and a central register, and they are all under the umbrella of the Spanish Ministry of Justice. And in that country, the central register is purely informative, and its structure and functions are legally established. Thus, it is in charge of the following: the management, handling, and informative disclosure of data received from the local commercial registers, archiving and disclosing the company's name and legal entities, publication of the official gazette of the commercial registry, and managing the register of companies and entities whose production is located offshore but are still considered Spanish. The objectives of the company register are these: responsible for registering the following entries and documents: the individual, entrepreneur, the mercantile company, the credit and insurance institutions, as well as the mutual guaranteed associations, collective investment institutions and pension funds, any legal or natural person when the law so provides, economic interest groupings, companies limited by guarantee, which may be described as companies primarily used for non-profit purposes and require legal status, acts and contracts established by law. The company register is also responsible for the legalization of company books, as well as the custody and publication of accounting documents. Documents and books registered at this company register are registration book and record, a commercial registry, a register book, and the record book, the ledger's account book and record book, a book of appointment of independent experts and auditors, the index inventory book. Books registered at the company as a company register will naturally be ordered and structured according to legislation, and as a rule, record books may be in different formats. Also, according to the local regulations, usually their pages will be numbered as well as correctly referenced and should include information on relevant aspects or irregularities detected and to be recorded. The same applies to registration books, which contain information on every company, data related to establishment, etc. In turn, commercial register books contain further information about company owners, established conditions, application dates, and the books and documents provided by the company. In the case of a ledger account book, pages will also be numbered and structured properly. There will include similar data regarding referenced companies and owners, as well as through the accounting information. This makes sense that the book of appointment of independent thus, it makes sense that the appointment of independent experts and auditors page are well structured and adequately paginated. With regard to this book type, it will record the following: audited company, date of audit, auditor, and audit results. In general, there should be available at any country's register a general index that provides the following information, if necessary: company name, owner or owner's address, a volume, registration form, and sheets number, as well as the tax ID. In each register, there will be an inventory of all the books and folders and profiles that are there in it. Thus, changes in staff in charge of such critical documentation will imply strict protocols that must be taken into consideration in terms of compliance. The fundamentals of the company register: public disclosure principles. Under the principle the company register is public, this implies that some information is made available to the public and some certificates may be obtained if requested. Certification for such public bodies is the only reliable means to validate the information for the records. Now, material disclosure principle. The principle implies the records for a company will only be effective against third party in good faith if they have been registered at the company register. A period of time may be necessary until registered records are fully effective. In case of discrepancies between what has been registered and what has been disclosed, third party may request the republication if it is more favorable to them. The good faith of the third party is presumed as long as it's not proven that it knew the act registered or not registered, the public registered act, or the mismatch between what is registered and what is published. Legality principle. For the registered act to be valid, it must be made and registered in accordance with the law. Therefore, the registrar must certify under his or her responsibility the legality of said act, in addition to the qualification and legitimation of the person who grants or subscribes the act and the validity of the account. Governments usually have the power to appeal these certifications. Mercantile contracts. And since ancient times, companies, entrepreneurs, and consumers have been establishing commercial relationships by signing different contracts to carry out their activity. In this section, we will study different types of commercial contracts, and we will take a closer look at the elements and characteristics that define each. Our objective will be to determine what the content is, utility, and the goal of each contract type, as well as examine the fundamental laws and regulations related to them. And this will help us to get a better understanding of how the different contracts on services, goods, and rights are connected to allow a proper functioning of the market economy. The legislation and regulations that control commercial contracts is very extensive, so we will focus only on the most important ones. A general framework. The distinction between civil law and commercial law still existing today is based on the tradition that goes back to antiquity, when commercial relationships relied on the ability to subsist on the transactions that were made between the consumer and the merchant. Nowadays, the basis of those transactions is profit-oriented and does not depend on subsistence. Fortunately, the successive legal reforms have made the mercantile rules that prevailed over civilians disappear. Even so, there is still a double regulation. To study the different contracts that have been previously mentioned, we can divide them according to the market in which they apply. Property market, in which the use of the ownership of property and rights is transmitted. Market services, in which very extensive services are traded. Financial market, in which the financing of the companies and consumer is traded. The procurement within general conditions. We understand procurement within general conditions of those contracts with general clauses pre-established and pre-written by the employer. Nowadays, when the market economy is overcrowded, this type of procurement means saving time and expenses for the employer. Contracts are not personalized and they do not have individualized clauses for each contracting client. These pre-written and general clauses should not contain abusive clauses and should undergo a control procedure to ensure that the employer and the client are legally bound. The controls through which these types of contracts need to pass within the framework of general conditions are the inclusion control. The purpose of the control is to guarantee that the person who signs a contract is aware of the total content of the contract in its conditions, obligations, and rights, giving each party a copy which is clearly written and understandable to both. The second control to which the contract will be subject is related to legality. It needs to be clear that any type of condition that applies to the contract must be in accordance with the current regulations. Any condition that is contrary to the preemptory norm will be invalid. Despite these controls, there are cases of abusive clauses that require greater protection. Therefore, in addition to not being contrary to the law, clauses and contractual conditions cannot be abusive either. Null stipulations, not negotiated, or all practices not expressly agreed, which contravene the requirements of good faith, give rise in a manner detrimental to the consumer or the user to the significant imbalance of the rights and obligations of the parties arising under the contract shall be regarded as unfair terms. Contracts with consumers. Consumers are currently considered the weakest party in the procurement process. Considering this, European legislators understand the need to protect them against procuring services or products offered by the company. Nowadays, regulations which were scattered in the past are now gathered together and defend the consumers and the users, creating bodies to advise and represent them. There is regulations of unfair clauses as well as legal and commercial guarantees. Consumer and user law regulates the contracting process with consumers by regulating, among other things, consumer services, customer services, information prior to the signing of contracts, purchase processes, delivery and supply of products and services, and the right of withdrawal, which allows consumers to refuse a contracted product or service. Remote or electronic procurement. With the advancement of new technologies, commercial relationships have changed substantially, and electronic commerce has been overtaken the rule of traditional commerce. However, this type of transaction may involve a risk or be inconvenient for the consumer if inadequate guarantees are not offered. Distance or electronic contracts imply that the consumer does not see how or know the product in person, which is risky as they might not acquire what they really want. Got it. To solve this problem concerning electronic and distance contracting, Spanish law, which will be used as an example of trade law, has been created various regulations and rules. The following regulations should be highlighted. Here they are. The general world degree, that's interesting, and so on and so forth. However, no specific regulations were established until the entry into force of law so-and-so on services of the Information Society Electronic, which incorporates the Spanish legislative directive and certain legal aspects of the Information Society services. And we'll make a brief reference to the most common legislation implemented recently. Measures to promote the Information Society. The law established that economically relevant companies which provide services to the public need to have an electronic means of communication that allows them to carry out the procedures of electronic procurement by means of an electronic signature. This provision is only aimed at companies with more than 100 employees or the ones that have the status of a large company for VAT purposes and that operate in certain economic sectors. Among others, companies engaged in the supply of electricity, water, gas, telecommunications, financial entities, insurance, shopping centers, transport, and travel agents. Measures concerning contracts of the public sector, which incorporate various EU directives into the legal system of the EU members. They aim to introduce improvements in the public procurement system, which has considerably strengthened the use of information technologies in public procurement. Electronic auctions, contractual advertising by electronic means, the use of electronic computer and telematic means. To protect consumers in e-procurement, several measures have been implemented in the EU as well. Aimed at protecting consumers against unfair practices. Commercial contract into the goods market, purchase sales contract concept. The sale is the contract by which one of the parties is obliged to deliver an item and the other one to satisfy a certain price in exchange. Essential elements of the contract sales: items, goods, and rights within the trade. Price, value that is asked the item. The goods or rights which is in the trade. Here are the terms. Price is the value that is asked for a thing or service. It needs to be true, reliable, and full and fair. Persons or parties: the seller, which is natural or legal entity transferring the property, and the buyer who acquires it. The formal. The contract of sales may be granted in writing, since the law may require such formality. In practice, it is usual for the agreement to be translated into a private document that serves as evidence. There are exceptions, for example, in the case of real estate or other contracts that are required to be done in writing. Validity, the capacity by which they said that every person capable of disposing of their goods can sell and any person capable of it can buy, and consent, which refers to an agreement between the parties on the price and the item. The duties of the seller in the contract are as follows. Transmitting the ownership or right. The seller is obliged to deliver the goods to the buyer. Keeping the good of the sale until delivery. The sale by itself does not imply transfer of ownership of the property, but forces that transmission. Delivering the good. Guaranteeing the buyer a useful possession. The seller has to answer the quality of the product. For the quality of the product, ensuring a peaceful possession to the buyer. The seller has to guarantee the ownership of the property or product. Indeed, answering for eviction. Eviction occurs in a sales contract when the buyer loses the item due to a final judicial decision by which a right prior to the sale is recognized. Eviction can be partial when the purchaser retains part of the item sold. This situation gives rise to a liability or on the account of the seller. Answering for the vices and hidden defects that a good has. In this case, the seller has to answer for the vices or defects of the product, both apparent and those not visible to the eye. Now we come to the obligations of the buyer. They have to pay the price. They have to pay interest in the case of delay or sale, which is deferred price. Receive the purchased good. They have to receiving the good in good condition. The swap. In this type of contract, both parties are considered sellers in terms of obligation, since both parties are those that deliver the product or good. A swap may be defined as a contract by which each of the contracting parties is obliged to give one thing in order to receive another thing. If one of the two parties has received the item promised in the swap and there is evidence that the other party does not own it, they may not be obliged to deliver the item they offered in exchange and will return the one he received. In other words, the swap is null. Whoever loses the eviction of the term received in a swap may choose between recovering the one he gave in exchange or claiming compensation for damages, but he may only use this right to recover the item he delivered while it remains in possession of the other, without prejudice to the rights acquired over it in good faith by a third party. Indeed, there is a provision that regulates swapping. Now we come to the intellectual property contracts. Intellectual property contracts are used to protect the author's creation, considering them uniquely creations and not produced in series or industrially. The creations that can be included within the intellectual property can be artistic or literary works, works of music, pieces are works of art, paintings, photographs, drawings, sculptures, or architectural design. Countries normally have offices or bodies involved in the registration and recognition of patents, trademarks, and intellectual property. One will usually find this kind of regulation generator factor. In fact, the intellectual property of a literary, artistic, or scientific work belongs to the author by the mere fact of creating. The content, intellectual property, is formed by person or patrimonial rights that attribute to the author the full disposition and the exclusive right of the exploitation of the work without further limitations than those imposed by law. Characteristics. The copy should be independent, incompatible, and cumulative with intellectual property and other rights inherent in the material in which intellectual creation is incorporated. The industrial property rights that may exist over the work and the other intellectual property rights considered recognized in Volume 2 of this law. Dissemination and publicity. Regarding the purpose of the provision of this law, the disclosure of a work means any expression of it that, with the author's consent, makes it accessible for the first time to the public by any means or process. Publication means that a number of copies of the work is made available to the public, and these copies allow satisfying the reasonable needs, taking into account the nature and purpose of the work. Industrial property contracts. The concept of industrial property includes 4 rights in Spain: the brand, the commercial name, the patent, and the know-how. Let's look first at the patent. The registration of a patent by an industrial property registry gives the right to exclusive exploitation of said patent for 20 years, after which the patent becomes public domain. According to Article 10, the right of the patent belongs to the inventor or his successors in title and is transferable by means of any recognized law, by all means recognized by law. When the same invention has been made by different people independently, the right of patent will belong to the one whose application has a previous date of filing in Spain, providing that such request is published in accordance with the provisions of Article 32. Spanish law establishes that new inventions that are susceptible to industrial application and involve inventive activity shall be patentable, even if they concern a product that is composed or contains biological materials, or a process by means of which biological matter is produced, transformed, or used. Biological matter, isolated from its natural environment or produced by means of a technical procedure, may be the subject of an invention even if it has previously occurred in nature. For the purpose of this law, biological matter shall be understood as the material containing self-reproducible or reproducible genetic information in a biological system, and by microbiological procedure, any procedure that uses a microbiological material, including an intervention in it, or that produces microbiological matter. The following elements will not be considered inventions in the sense of the previous section: discoveries, scientific theories, and mathematical methods; literary, artistic works, or any other aesthetic creation, as well as the scientific work; the plans, rules, or methods for the exercise of intellectual activities, for games or for economic commercial activities, as well as computer programs; and the ways of presenting the information. Brand and trade names. We can define a brand as those signs, distinctions, and denominations that commercially identify a product, company, or service in the market. The brand can contain words, images, symbols, sounds, figures, etc. At the legal level, the law of brands regulates this. We understand know-how as a set of non-patented practices that are typical of a company and facilitate the production of a service or product. These practices are considered to be an added value that can be transmitted through licensing agreements that allow their use. Now we get to commercial contracts in the services department. For example, rental services contracts. Rental services or outsourcing services agreements are normally characterized by lessees or lessees' commitment to perform a specific activity. Unlike previous contracts related to the goods market, in this type of contract, an obligation to perform rather than to provide a good or services include. The activity or services that may be performed are very different. Currently, outsourcing of a service is very common since companies need to engage outside firms to perform services instead of hiring their own staff to perform it. Examples of outsourcing may be the hiring of training staff for specific courses for the employees, cleaning, labor, consultants, catering services, or auditors. In intermediation contracts are of mandate and commission. The mandate contract is an agreement by which a person is obliged to provide a service and do something on behalf of or at the request of another. Usually the nature of the mandate is free of charge unless the agent asks to perform services of the mandate, which would presume the obligation to repay it. Whether the mandate contract is binding or not is conditioned by the actions of the mediator, depending on whether the mediator acts on his or her own behalf or on behalf of another. If he or she acts in his or her own name, he or she is the one who has the obligation. Whereas if he or she acts on behalf of a third party, there is no relationship between the mediator and the third party. This is the reason why the third party must know the limits of the power granted, since only the principal would be bound within those limits. Agreements commonly terminate due to revocation, resigning of the chief executive officer, and by the death or insolvency of one of the partners. The commission shall terminate due to revocation of the customer, death of the commissioning agent. Oh. Brokerage contracts. A brokerage contract is an atypical contract that sometimes has no general regulation. This type of contract is characterized by the intermediary search for a third party with certain conditions to get in a contract with the main party. In these contracts, the mediator has no participation whatsoever. If it is not covered by the commercial code, there are no regulations other than to limit the freedom of agreements between mediator and principal. But even so, if it is a commercial contract governed by the jurisdiction, commerce legislation, and civil jurisdiction. These contracts are used, for example, in matrimonial or real estate agencies. Usually there are specific commercial operations and there is no commercial continuity between the mediator and the principal. However, I was informed that that may not be so. Usually there are commercial operations and there's no commercial continuity between the mediator and the principal. In the mediation, the mediator puts the principal in contact with the future client or supplier, lacking the proxy power to perform any specific business. Freedom of covenant among the parties is very wide and there is no need to negotiate exclusively among them. The mediator may be natural or legal entity, and the principal can revoke the contract freely. Legal business environment, Mod 1, Part 2, Contracts and Mandate and Commission. A mandate contract is an agreement by which a person is obligated to provide a service or something on behalf of the request of another. And usually the nature of the mandate is free of charge unless the agent has to perform services of the mandate, which would presume the obligation to repay it. And whether the mandate contact is binding or not is considered conditioned by the action of the mediator, depending on whether the mediator acts on his own behalf or on the behalf of another. If he or she acts in his own name, he or she is the one with the obligation. Whereas if he acts on behalf of a third party, there is no relationship between the mediator and the third party. And this is the reason why the third party must know the limits of the power granted. Only the principal would be bound. And here we are again. The agreements terminate due to following things: revocation, resignation of the chief executive officer, death or insolvency of one of the partners, and the commission shall be terminated with the revocation by the customer or the death of the commission salesman. So then we come to these brokerage contracts. It's an atypical contract that sometimes has no general regulation. This type of contract is characterized by the intermediary search for a third party with certain conditions to get into contract with the main party. If these contracts, the mediator has no participation whatsoever. If it is not covered by the commercial code, there are no regulations that limit the freedom of the agreements between mediator and principal. And even so, it is a commercial contract governed by the jurisdiction, commercial legislation, and civil. And these contracts are usually, for example, matrimonial or real estate agencies. Usually these specific commercial operations, and there's no commercial continuity between the mediator and the principal. And the mediator puts the principal in contract with the future client or supplier lacking the proxy power to perform any specific business. The freedom of covenant among the parties is very wide, and there's no need to negotiate exclusivity with them. The mediator may be natural or a legal entity, and the principal may revoke the contract freely. The brokerage contract shall terminate due to the implementation of the mandate, the death or disqualification of the mediator, or the resignation of the mediator. Now, an agency contract is an agreement where a natural or legal entity referred to as an agent is obliged in exchange for remuneration to guarantee acts or trade transactions on behalf of a third party, or to promote or conclude them on the behalf of others as an independent intermediary without assuming, unless otherwise agreed, the risk or venture of such operations against another in a continuous or stable manner. The agent is obliged to take care with the diligence of the organized business person, of the promotion and completion of the acts or operations entrusted to them, and give the principal all the information necessary for the proper management of the act or operation whose promotion and, as the case of completion, has been entrusted to him. What is of particular interest is the solvency of the third party with which there are pending operations of completion or execution, and they develop his or her activities in accordance with the reasonable instructions received by the principal, provided that they do not affect his or her independence, and to receive on behalf of the employer any kind of third-party claims concerning defects or flaws in quality or quantity of the goods and services provided and sold as a result of the operations promoted, even if they had not been completed. And the employer is obliged to make available to the agent sufficiently in advance and in appropriate quantity the samples, catalogs, fees, and other documents necessary for the exercise of his or her professional activity, and to obtain for his agent all the information necessary for the execution of the agency contract, and to notify the agent as soon as he or she anticipates that the volume of the action or operations will be significantly lower than the agent could have expected, to pay for the agreed remuneration and keep an independent accounting of the acts or operations related to each principal on whose behalf he acts. Now, the agent remuneration, well, it will consist of a fixed amount, a commission, or a combination of both, and in the absence of an agreement, the remuneration shall be set according to the trade usages of the place where the agent is carrying out his or her activity. If they do not exist, the agent will be entitled to reasonable remuneration, taking into account the circumstances, and the commission is understood to be any element of remuneration that varies depending on the volume or value of the acts or operations promoted and where appropriate and concluded by the agent. And when the agent is totally or partially paid on commission, the provisions of the following articles of this section shall be observed. Prohibition of competition. So, one, among the stipulations of the agency contract, the parties may include a restriction or limitation of the professional activities to be developed by the agent once the said contract is terminated. The restraint of trade clause cannot exceed 2 years from the agency contract termination date. If the agency contract has been agreed for a shorter period, the restraint of the trade clause cannot last longer than 1 year. The restraint of trade clause, which must be executed in writing to be valid, may be extended only to the geographical area and to the group of persons entrusted to the agent, and may only affect the class of goods and services subject to the acts of the operation promoted or concluded by the agent. Termination of contract. The agency contract agreed for a specific time will be terminated upon fulfillment of the agreed term, of course, but notwithstanding the provisions of the previous number, the fixed term agent contract that continue to be executed by both parties after the termination of the initially agreed time should be converted into an open-ended contract. Termination of the agency contract for an indefinite period. One of the parties may terminate the agency contract of indefinite duration by notice. The notice period has to be equal to 1 month for every year that the contract remains in force. If the agency contract has been valid for less than 1 year, the notice period will be 1 month. The party may agree to a longer period of notice. The term for the agent should not be shorter than that for the principal. Unless otherwise agreed, the end of the notice period will coincide with the last day of the month. To determine the period of notice of fixed-term contracts that have been converted by law into an open-ended contract, the duration of the fixed-term contract shall be computed, adding to it the time since it became an open-ended contract. Now, the exceptions to the previous rules. Each one of the parties in an agency agreement for a specific or indefinite period may terminate the contract at any time without the need for prior notice in the following cases: where the other party has breached totally or partially the obligation legally or contractually established, or when the other party has declared bankruptcy. In such cases, it will be understood that the contract ends upon the receipt of the written notice that states the will to terminate and reason for the termination. Compensation in agency contracts. Well, compensation for customers. When the agency contract terminates, whether for a fixed or indefinite period, the agent who has brought the principal new clients or has significantly increased the operations with the existing clientele will be entitled to compensation if his or her previous activity continues to be substantially of benefit to the employer and it is equitably appropriate for other circumstances that may arise, in particular the existence of agreements to limit competition or the commissions lost by the agent. And the right to compensation for clients also exists in the event of contract termination due to the death or declaration of death of the agent. Compensation may not exceed, in any case, the average annual amount of the remuneration received by the agent during the last 5 years or during the entire period of the contract, if it is shorter. Compensation for damages. Without prejudice to the clientele's compensation, the employer who unilaterally denounces the agent's open-ended contract will be obligated to compensate the damage. Part 3, compensation for damages without prejudice to the clientele compensation. The employer who unilaterally denounces the agent's open-ended contract will be obliged to compensate the damage that the earlier termination has caused to the agent, provided that the termination does not allow the amortization of the expenses that the agent instructed by the employer has made for the execution of the contract. Cases where there is no right of compensation, the agent will not be entitled to compensation for clients or damages when the employer has terminated the contract due to the breach of obligations legally or contractually established by the agent, or when the agent denounced the contract unless the complaint was caused by circumstances attributable to the employer, or it was based on the age, disability, or illness of the agent and could not be reasonably required to continue his or her activities, or when, with the consent of the employer, the agent has assigned the rights and obligations that he held under the agency contract to a third party. Contracts of distribution, commercial concession, and franchise. Distribution or commercial concession contract. The distribution or commercial concession contract is a contract not specifically regulated in our law. It is an agreement by which the grantor and the concessionaire commit to acquire under certain previously agreed conditions certain products to resell them in a determined geographical area under the supervision of the concessionaire. The characteristics of this kind of contract: collaboration between business person and grantor to bring and distribute a trademark service or product to the market, selling the goods in the same state in which the concessionaire supplied them without transforming them. The concessionaire or reseller must give the buyers the attention that they need once the sale is performed. The concessionaire must assume the risks of the commercial transactions carried out with the customers by the grantor. The grantor receives benefits from what the concessionaire sells. Now, the obligations of the grantor, supplying the agreed merchandise to the concessionaire, in the case of exclusivity, the supply of products or services cannot be offered to other resellers who act in the same area, and if the grantor is the manufacturer of the product, they are obliged to assume responsibility for those products. The obligations of the concessionaire, the purchase of a certain number of the products, the recruitment of qualified staff, having optimal facilities for the development of the activity, and promotion of the offered products. Determination of this type of contract will depend on the cause agreed upon in it. And then we have a franchise agreement. The franchise contract is an agreement whereby the franchisor allows a franchisee to use their system and market certain products and services in exchange for an economic compensation. Unlike the distribution or commercial concession contract, the franchisor must transmit its work methodology, know-how, and its commercial methods. The franchisor must design, direct, and pay for their advertising campaign to grow the brand awareness. So here is a diagram of that. The franchisor, a franchisee. Brand, service, know-how, support all has to come, and fees, royalties will go to the franchisee. Franchisor, franchisee, franchise. Oh, I think they may have think that's an or there. Yeah, that makes some sort of sense. No, they think they messed this up, actually. Well, that part is certainly right. Yeah, because they're not paying fees to them. That's the other way around. I think they may have messed up that diagram a wee bit. Anyway, the three elements that determine the basic content of this type of contract are the brand, the know-how, the continued support. The franchise agreement, as it's not specifically regulated, needs to clearly outline the essential elements related to any contract and include a detailed regulation of the basic contract. There's a header. The header should provide the information, identification details of the franchisor and the franchisee, expose the detailed content of the obligations and commitments that affect both parties, a transfer of the brand, trademarks and distinguishing symbols, and usage rules, transmission of the know-how, requirements of the facility, condition of the supply of the product and or service, a geographical and territorial exclusivity of the franchise, technical and technological support, advertising campaigns, duration of the contract must be stated, reasons for the contract termination, and etc. Main difference between this contract and the distribution contract is the obligation of the franchisor to transmit his or her know-how. Franchisor is obliged to transmit the essence of the business that is proven to be effective so that the principal can act as an employee under the trademark. Advertisement contracts. The general law of advertising includes four types of contract. Advertising contract, in which the advertiser entrusts an advertising agency in return for some economic compensation with the implementation, creation, preparation, and programming of an advertising campaign. And when the agency creates an advertising campaign, the rules of the contract of the advertising creation shall also apply. The contracts for disseminating advertising. The contract for disseminating advertising is the one by which, in exchange for an amount set at a pre-established rate, a medium allows the advertiser or agency to use the units of space and time available and to develop the technical activity necessary to achieve the advertising result. And the advertising creation contracts is the one by which, in exchange for an amount of money, a natural or legal entity is obliged in favor of the advertiser or agency to devise and develop an advertising campaign project, part of which is the advertising element. Advertising creations can benefit from intellectual or industrial property rights when they meet the requirements of the regulation. Notwithstanding the provisions of the preceding paragraph, the rights of the exploitation of the advertising otherwise agreed will be assigned exclusively to the advertiser or agent under the contract of advertising creation and for the same. Now we come to sponsorship contracts. The advertiser sponsorship contract is an agreement by which the sponsored party, in exchange for financial aid in carrying out their activity related to sports, charities, culture, science, or other activities, agrees to collaborate in the sponsor's advertising. Advertising sponsorship contracts are regulated by the advertising broadcast contract rules, if applicable. According to this law, there are certain conditions for subjects participating in these advertising contracts. And these are that the advertiser, natural or legal entity in whose interest advertising is carried out, the advertising agency, a natural or legal entity who are in charge of organizing, creating, preparing, scheduling, and executing advertising on behalf of the advertiser, and advertising means, natural or legal entities, publics or private, who, in a regular and organized manner, dedicate themselves to the dissemination of advertising through the media or social media, whose ownership they hold. Contracts in the financial market. Now, this means the financing for a company, credit or value of the market. The financial market is a physical or virtual place where the consumer and companies obtain financing. Consumer or companies interact in order to obtain financing or negotiate assets, financial instruments, and products. Given the complexity of the financial market, we will reduce the classification to two different markets. The credit market, and in the credit market, financial intermediaries receive money from investors through deposit contracts. An agent makes the credit obtained available to third parties. For this reason, there are two different relationships created. On the one hand, a contract with the investor is signed, and on the other hand, a contract with the person who receives the credit or the loan. It will always be the credit institution that must commit to meeting the obligations agreed to in these contracts. Now we come to the stock market. In this type of market, a company that needs funding offers value stocks to investor. The investor acts as a lender with the business person or company that must return the money of the issued bond within a certain period of time, as well as the interest that has been agreed upon. The investor acquires rights to these shares and the issuer obligations to the investor. The advance sale of the securities before the agreed term is carried out in the stock markets, in which these value stocks can be sold and or acquired. Legal business environment. Loan markets. The loan contract, regulated by the Code of Commerce and Civil Code, is defined by the Royal Decree, as you see here, on which party gives one another not fungible to use for a certain time, and in return which is called bailment, well, with the condition of returning the same species and quality, in which case it is returned simply, and the loan is essentially free. The simple loan can be free or with an agreement to pay interest. The loans regulated by the Mercantile Code are those that are made by a merchant for that loans for commercial operations, while the other loans are regulated by the Civil Code. Since the loan, as we have said, is free, the interest that may be agreed between parties must be in writing. The purpose of the interest is that the lender obtains a benefit and to avoid a negative cause that inflation may entail. Although the CCO, in its Article 315, says that there is no limit on the amount of interest, the Supreme Court admits that the interest on the commercial loan can be greater than a civil loan. According to these articles that you see here, if the provider receives capital without stating that it reserves the right to charge interest, the obligation to pay interest expires, and the borrower who pays interest without it being stipulated cannot claim it as an undue payment. The borrower, rather. Consumers. The consumer law establishes a special regime for loans in favor of consumers. This regulation tries to prevent abuse and provide consumers with sufficient information. The law establishes the content of the contract and regulates, among other things, the total cost of the loan, the early repayment, the annual equivalent rate, etc. The transparency duties regarding the contract are as follows. The companies must have at their disposal the general conditions of the contract they use. Consumers will not have to face any expenses or assume any commitment for receiving them. The information must be available on the website of the company if they have it, and it establishes open to the public or offices where the services are provided. And the accessibility of persons with disability to the information provided in the previous section must be guaranteed in the terms required by the law and or regulation. We also have a transparency duty regarding prices. The companies will freely establish their rates of commission, conditions, and expenses, which can be passed on to the consumer without other limitations than those contained in this law in terms of abusive clauses. The fees for commissions and compensations and repercussions, including advisory activities, shall indicate the assumptions and the periodicity with which they are applicable. The commission or compensations and expenses passed on must respond to services actually provided or expenses incurred. Under no circumstances may the commission or expenses for services not accepted or explicitly requested by the consumer be charged. And of course, companies will not be able to charge higher amounts than those derived from the fees. This applies to more burdensome conditions or unforeseen expenses. The companies are obliged to notify the registry in which they are registered prior to their application of the prices of the services, the fees of the commissions, or compensations and expenses that may apply at most of the operations and services that they lend, and of the maximum interest rates of the products they market, including, where applicable, interest rates for late payments. The prices, fees, and expenses applicable to the previous section will be included in a brochure, which will be written in a clear, precise, and understandable way, avoiding unnecessary or irrelevant concepts that may confuse the consumer. Leasing. Elements involved in the leasing contract are the manufacturer of the good, the leasing company, and the user of the asset. A lease is a contract by which one party agrees to rent property owned by another party. Leasing is an operation where the company, in exchange for regular payments, rents to another a certain good for a specified time. Once the agreed period has expired, the user can purchase the product by paying a residual price, extend the contract, or terminate it. And in this type of contract, the liability clauses must be well defined, since the user, when dealing directly with the leasing company, cannot claim damages from the manufacturer of the product. Bank contracts. Bank contracts is defined as an agreement to create, modify, or terminate a legal relationship of a banking nature. They consist of nominal interest rates, a date of payments, the dates of the interest accruals, methods used to calculation of interest, the commissions, the expenses, the rights of the bank, the rights of the consumer, and most loan operations or credit institutions directly or indirectly involved against the irrelevance of bank contracts. Banking operations can be classified as active operations, where the bank is one of the loans is the one that loans, opening a credit or loan. Passive operations, where the bank receives a loan in irregular deposits, and neutral operations, where there is a different service is given to the credit relationship. The current account contract should be highlighted in bank contract. We can define the current account contract as a management contract, an accounting technique in which the bank provides the customer with cash services by making collections and payments for the customer, and also by controlling income and withdrawal. Within the cash services, we can find direct debit of receipts, ATM banking, online transfers, payments of checks, credit card services, and so on and so forth. Credit and debit credit and debt transactions are recorded, and each operation obtaining a balance in favor of the subjects. Current accounts may be pools or indifferent. The pool are those that require the signature of all of the account holders to withdraw money. Despite the insufficient regulation of banking contracts, considering most of them atypical, the Bank of Spain has a claim service where reports are made on appropriate practices and not that are followed by the credit institutions despite not being binding.